Good afternoon, everybody. I'm Tony Vernetti with Feds. We're just going to give everybody a little bit more time to get logged in here. So we'll just probably start in a minute or so. Okay, let's go ahead and get started. I'm Tony Vernetti. I'm the president and founder of Feds Protection, the leading provider of professional liability insurance for federal employees and specifically law enforcement officers. We're the one company that's endorsed by all the leading federal law enforcement associations. And I'm going to serve as the moderator for today's program. But let me introduce the real star of the show, our presenter, Michael Scarlett. Michael is an attorney at the law firm of Shaw, Bransford, and Roth, where he specializes in representing federal employees in a wide variety of federal employment matters and issues. Michael has his undergrad degree from Temple University and law degree from the George Mason University School of Law. So we are super thrilled that Michael was able to do this presentation for our insureds and the larger law enforcement community as well. Michael and his law firm, Shaw, Bransford, and Roth, are the lead panel counsel on the Fed's liability program. So they are the ones with boots on the ground, day in and day out, representing and defending federal law enforcement officers. So hearing directly from them on these issues, I really believe will be invaluable. This is a presentation that we saw Michael do at WIFL, Women in Federal Law Enforcement Conference recently. I'm pretty impressed with it, the information. Got a lot of accolades with it, so we asked him to kind of reproduce it for us, for our insureds and our larger community. So before I turn it over to Michael, and in an effort to make this presentation as engaging as we can, I do want to encourage everyone to utilize the chat function on the Teams platform and place any questions that you may have in there. And I'll be monitoring them and I'll present them to Michael, where I think it is appropriate, where it fits in. And if we don't get to your questions, we're definitely going to save time in the end and make sure we get any of those questions answered. So without any further ado, let me turn it over to Michael to get us started.
All right, thanks for the introduction, Tony, and welcome everyone to this presentation. We're talking today about really what happens when allegations are made against you for doing your job. Where do they come from and where do they go? And, first I have to applaud you for attending this presentation. It's not an easy topic to talk about, but it's an important one. So bravo to you. And so what I did here, I broke this down into three different buckets, really. Three buckets where allegations may come from and where you may encounter them throughout your law enforcement career. So, first you'll see I have administrative matters, and that really relates to administrative investigations, disciplinary actions, and your appeal processes and rights of those disciplinary actions. Then we have civil suits. So you as a law enforcement officer being sued in your individual capacity. And we're going to be talking about Bivens lawsuits, which I'm sure many of you have heard of before, as well as Religious Freedom Restoration Act lawsuits, which you may not have heard as much about before. And then this last bucket, criminal charges. So investigations and prosecution of certain criminal offenses. Now, I'll tell you right now, this is a lot to cover in the amount of time we have today. And you could probably have an hour presentation on any single one of these topics. But what I'm trying to do is give you a broad overview of these allegations, where they come from and where they go. So let's get started. The first topic we're going to talk about are administrative matters. And so first, I want to talk about you as a law enforcement officer. Well, you know, I see a lot of law enforcement officer clients. It's a large part of my client base. And, you know, there's something to be said. I think a lot of law enforcement officers um, find it very common and more prone to sort of being the subject of allegations. And, that leaves the question, why? Why do you see more allegations than the common federal employee? Well, it's really your job. It's unique to the federal workforce. You get to carry a weapon, you have a badge, you have arrest authority. And then on top of this, you interact with the public much more than the common federal employee. So, what does that mean for you? Well, because you carry a weapon, you have a badge, you have arrest authority, you're held to a higher standard than the common federal employee. It's in the law. You are held to a higher standard. And what this also means is that your job is more regulated. There's more rules you have to follow. There's more policies, executive orders, guidance, regulations. And then because you interact with the public more, you're going to find yourself more susceptible to complaints. And just the very nature of what you do for a living makes you more susceptible to complaints. There's friction there at times. And these sort of privileges that you have as a part of your job duties are unique to you. They'll work their way into allegations and potential charges against you. So, how do these administrative processes start? Well, they usually start with some kind of an investigation. And those investigations, they are usually rooted in some kind of a complaint or referral. Complaints can go to management, they could go to human resources, they could go to some kind of investigatory body or office like the OIG, OSC, EEO, or, they could even go to like Congress and get trickled down to the agency level itself. But who do these complaints come from? Well, they could come from, if you're a manager, your subordinate employees. They could come from your management itself. They could come from your peers and colleagues, but they could also come from members of the public. Now, one tip I typically give my clients is that it's generally not advisable to seek out the source of a complaint. And that reason is really twofold. One, it could create an appearance that you're looking to interfere with an investigation, or two, that you are creating an appearance that you're looking to retaliate against the complainant. And, you know, as helpful as it may be to know where these allegations come from, you actually don't have a right to that information. And so for those reasons, I typically tell my clients, stay away from that. And so one question I very often get from clients when they find themselves, the subject of an investigation is, how can this impact my job duties? Well, for law enforcement officers, that's pretty special and unique as well, because the agency can suspend your law enforcement authority. Your credentials, badge, and weapons would be surrendered, usually to someone in your management or your chief. And the length of time, that varies. It could be weeks, but it could also be months or years. It really depends on how long the investigation's conducted. And that itself has an impact on you. Um, you're usually placed on some kind of clerical or administrative duties. You're not out in the field doing your job. And during this period of time, if the investigation keeps going on for a while, your training may lapse. So then when your law enforcement authorities eventually restored, you'd have to go back and take all that training before you could actually go out in the field. And one thing I could say from my experience representing law enforcement officers is that this is personal. In fact, I would say that this is probably even more personal than any kind of disciplinary action that may result from an investigation because you work hard to get here. You know, you go to training, you go to FLETC, and then you work hard on daily on your job and you care about your job very much. So, you know, to have your law enforcement authority stripped away, it's personal, but you got to compartmentalize that. And, you know, one thing I often tell my clients is that you don't have a right to your job duties. You have a right to your grade, you have a right to your pay, but you don't have a right to your job duties. So, you know, I always tell my clients, compartmentalize that, put your head down, work hard, show them that you're a good worker. Now, who's investigating the allegations? Well, it could come from numerous bodies and offices. As you all know, the government is filled with lots of acronyms. I'm just going to touch on a couple of them right now. So OIGs, these are special agents. They're 1811, so you know they carry a gun, they carry a badge, and so because of that, they're able to conduct both criminal and administrative investigations. Now, for administrative matters, OIGs usually get involved where there's no OPR. Otherwise, for you as a law enforcement officer, OIGs are very often looking at criminal misconduct. Then we have offices of professional responsibility, or sometimes what are called internal affairs offices. Now, these are professional investigators. They're not 1811s, but they are professional. They're skilled and they're trained to do their job. They're trained to get information out of you, but they are limited to administrative investigations. But the scope, you know, the breadth of those administrative investigations is usually pretty broad. They're able to look into really any kind of allegations of personnel misconduct. Then we have EEO offices. And, you know, I'll say this really applies to you law enforcement officers that are managers. And I say that because that's usually where these allegations are directed to. As a manager, you make personnel decisions, and your personnel decisions affecting your subordinate employees, you know, your employees may disagree with the decisions and actions that you take. And when they disagree with those kinds of actions, they may be looking for the reason. And maybe they believe that the reason's unlawful and they think it's some kind of unlawful discrimination. Well, you know, usually when that kind of thing comes in, it's referred out to a contract EEO investigator. And that's all these people do. They just look at and investigate EEO allegations. Then we have what are called management inquiries, and these are usually conducted by human resources officials as well as management officials. It could even be your supervisor. But the coverage and scope of these is pretty similar to an internal affairs investigation. They look into broad allegations of personnel misconduct, but it's a little bit more informal. And usually these people aren't as trained in conducting investigations like an OPR investigator. Now, if the allegations against you are stained, it's very likely you'll receive some kind of proposed disciplinary action. Proposed discipline may come from someone in your chain of command, like your first or second level supervisor, or maybe your agency adheres to some kind of centralized process, like they use a board to propose a disciplinary action against you. For example, ATF, they use the PRB, the Professional Review Board. But I'll tell you this right now, it's something I tell my clients. When you get issued a proposed disciplinary action, it's not the time or place to contest it. I can assure you that no matter what you say to your proposing official, it's not going to get them to pull back that piece of paper. So listen and be professional. And I say that because you have rights. Now, what rights do you have? Most federal employees are covered under 5 U.S.C. Chapter 75. And what that statute gives you is notice of the charge, a right to the notice of the charges against you, a right to review the evidence relied upon, and a right to respond to the charges against you in writing and or orally. You also have a right to an attorney. Now, one thing to keep in mind when you get a proposal is that the agency carries the burden of proof of the charged misconduct, and they must do so by a preponderance of the evidence. And what that means is that they must prove that's more likely true than untrue that you engaged in the charged misconduct. And breaking that down into, layperson speak, think of a scale like that image there. If you took 1 grain of salt and you put it on one side of the scale, well, that just tips the scale. It balances it just a little bit. All you need is over 50%. So it's not the greatest burden of proof in the judicial system. And I said you have notice of the charges against you. That's where we look at the proposal. It's your notice of the charged misconduct. By law, the government must issue you a proposal before it could issue suspensions, demotions, and removals. But the process for reprimands varies based on your agency. For example, if you worked at the VA, you would get a proposal, but other agencies, they just issue you the reprimand and give you the opportunity to grieve it after it's issued. What does the proposal include? The proposed penalty against you, the charges against you, the specifications, and the penalty analysis. Now, the charge is usually some kind of like broad generic label, and then the specifications are, more specific to the action at issue. So, for example, say that the charge against you is misuse of a GOV, okay? Underneath that, the agency can have multiple specifications. I've seen agencies have like 27 specifications before, but they would only really ultimately need to prove one of them to prove that overall charge. So, if the charge is misuse of a GOV, there could be a specification one that says on June 1st, 2024, you misuse your GOV to pick up your child from daycare. Or on specification 2 on August 1st, 2024, you misuse your GOV to pick up your wife from her hair appointment. That's how it would look. Then I mentioned you also have a right to review the evidence. Well, I bold here the right to review because not every agency actually gives you a copy of the evidence file. Now, most do give you a copy of the evidence file, whether you have to request it or not, but not all do give you it. For example, I mentioned here FBI and DEA give you a right to review it, but you'd have to go into one of their offices and review a physical copy of it. Now, what is the evidence file? In short, it's what the proposing official looks at to issue the proposal against you. Evidence files could be 50 pages, they could be 5,000 pages. If you're under investigation, maybe it includes an ROI, so it include your witness statement. It may include the witness statements of others. It could include emails, policies. The scope of what it is very broad. It's just whatever the proposing official lied on. Ultimately, the government must show that the penalty imposed against you is within the bounds of reasonableness. Now, the bounds of reasonableness does not mean the lowest reasonable penalty. The agency is entitled by law to impose the maximum reasonable penalty. So say that the charge against you, the bounds of reasonableness, on the low end may be a reprimand, but on the high end is a removal. That removal is still within the bounds of reasonableness. But how is that decided? How is reasonableness decided? Well, it comes from a Merit Systems Protection Board case from 1981, Douglas v. Veterans Administration. There's 12 factors that they look at. And you can look at them here for yourself. I'm not going to go through every single one of them. I could probably do a whole webinar on the Douglas factors. But a couple I'll mention are one, your job level and type of employment. As I mentioned earlier, law enforcement officers are held to a higher standard. That could be used against you to aggravate the penalty. Or let's look at the fifth one here, effect of the offense upon the employee's ability to perform at a satisfactory level. Well, we're going to get into this a little bit later, but say that you get a lack of candor charge against you, the government may say you're potentially giglio impaired. And when they do that, they use that to say you can't satisfactorily perform your duties in the future. And they use that to aggravate the penalty, almost always with a proposed removal. But there's also, some of these Douglas factors that, could work in your favor. Say that you have no prior record of discipline. You'd want to highlight that. Or say that you get an excellent performance evaluation awards every year. You'd want to highlight that too. But there's a lot of factors here. And, you'd want to look at everyone if you got a proposed action against you. Ultimately, you will receive a decision. And the law really requires the agency to inform you of its decision in writing. It'll include the charges that the agency's upheld, as well as their penalty determination. And the same advice I give to my clients as I give in the proposal stage is, just listen, be professional, because once again, you do have rights that follow a decision. And your rights really depend on the penalty imposed against you. Um, for example, you have a right to appeal with the Merit Systems Protection Board, but the Merit Systems Protection Board will only hear um, disciplinary actions of 15-day suspensions or more, demotions, and removals. And what the Merit Systems Protection Board is, in short, it's a neutral administrative body that really overhears all kinds of, personnel actions like this across the federal government. But then if you get a suspension of 14 days or less, what will happen is, you may have the opportunity to go through your agency's own administrative grievance procedures, and they vary based on agency. But, regardless of the penalty, if you are in a bargaining unit, which is for law enforcement officers, very limited to uniform law enforcement officers, you may have the option of going through negotiated grievance procedures, working with your union steward on that, and going through arbitration. You could also file complaints. One with the Office of Special Counsel if you believe that there's a prohibited personal practice. So if you believe that, maybe there is a whistleblower retaliation, that's really OSC's bread and butter. Or you could file an EEO complaint that, you're saying that the action taken against you is unlawful. It's based on discrimination or harassment or reprisal based on a protected class. Now, a lot of people contact my law firm and say that they get a proposed removal. And they think that, filing an EEO complaint is absolutely their best course of action. And, I can assure you, no attorney in my law firm would agree with that. And I say that because you heard me earlier say the government carries the burden of proof on, the merits of the charges against you. So, you would go to the Merit Systems Protection Board on a removal action. Let the government carry its burden of proof. With an EEO complaint, that's your burden of proof. So, you have to prove that the action was taken because of your protected class. And that requires intent, and that is hard to prove. I have a note here, you may only get to pick one form that challenge a disciplinary action. So you want to think about your options and you want to choose wisely. I mentioned earlier Giglio. Many of you, as law enforcement officers, federal law enforcement officers, are probably quite familiar with the term. Well, it's rooted in the Fifth and 14th Amendments. And in short, what those amendments say is that the government cannot deprive people of life, liberty, or property without due process. Giglio's about protecting those rights for criminal defendants, and it really stems from two 60s and 70s Supreme Court cases. But just breaking it down a little bit, what does Giglio impairment mean? In short, as law enforcement officers, you serve as witnesses in trial. So if your credibility, if your character for truthfulness are in question, you may be labeled Giglio impaired. But, being labeled Giglio impaired is more complicated than it seems. It's actually a decision a decision that's made by the U.S. Attorney's Office. But agencies still say when they get like a lack of candor charge, for example, that you are potentially Giglio impaired, and they could use that to aggravate a penalty against you. And, I note there that it's a career killer because they almost always use it to propose a removal action. So we talked about investigations earlier, so I just kind of want to highlight some, areas where Giglio issues may arise during an internal investigation. So providing false information. So if you're under investigation for your relationship with a colleague and you tell the investigator that your colleague was a friend, but you were actually dating, even if it was, just between you two, and those are the only people that know about it, and you lie about that or mislead the investigator, that is giglio. If you omit details, so say you work in the BOP and under investigation is your altercation with an inmate. And when you're interviewed on this, you leave out details about how that altercation started, specifically your role in that. Whether, say that you pushed the inmate or you used some cuss words with the inmate, you excited the inmate in some way. If you leave those details out, that's giglio. Misleading the investigator. So, say you're under investigation for your use of force during a protest, or maybe your colleagues' use of force, and you tell the investigator you just bumped into the protester, or maybe you just pushed the protester a little bit. But then later video footage comes out and it turns out you used your baton. Well, that would be giglio. You're misleading the investigator on the extent of your contact with the protester. One common one that comes up, lying about your ability to remember. Listen, not knowing or not remembering something is a fine answer if it's the truth. But if it's not the truth, you can't just use that to avoid answering a question. And for, those of you who don't really understand or know the distinction between the two terms of art, I'll break it down for you. If you don't know something, that means you never knew it. At no point in your life did you know this information. So, for example, like what's the recipe to Coca-Cola? Or how do you build a nuclear bomb? You just don't know that information. Now, when you don't remember something, that means at some point in time you knew it, but sitting here today, you just don't. So, an example of that would be what you have for dinner on May 1st, 2023. Unless if it's your anniversary or some kind of special occasion, odds are you're probably not going to remember. But then Giglio could also come up in the performance of your duties. So going back to providing false information, say that you're a police officer and you have to fill out police reports timely and you backdate that police report. Well, when you backdate that police report, that's providing false information and that's giglio. Or say that you intentionally wrongly encode your time and attendance to make it maybe get overtime. Well, providing that false information, that is giglio. Then omitting material information. So say you're talking to your supervisor, hey, I dinged up my GOV, and you leave out the part with your supervisor that you're on your cell phone. Maybe you're looking at a map. Maybe you're on Instagram, and that's how you ended up crashing your GOV. Well, that's omitting, material details to your supervisor. So that is giglio. Or mischaracterizing events. So say that a colleague comes up to you, has this great idea for some kind of business plan or some kind of, just general idea in the office. Um, and then you package that and present that to your supervisor as your own, and you don't credit your colleague's involvement at all. Well, you're mischaracterizing these events, and that could be giglio. So that really wraps up, my 101 on allegations of wrongdoing and administrative matters. So we talked about,
So Michael,
investigations.
I got
Yeah.
one. I got one question that came in before we switched to before two questions actually before we switched
Okay.
to civil. The
Sure.
first has to do with GOB misuse and the willful misuse. As you know, it's the only discipline in the government where Congress has legislated what the mandatory penalty would be, 30-day suspension. The
They
question is
have.
about that.
Yeah.
And I guess this question really goes to your kind of like mitigation discussion and your Douglas factor discussion. Are you ever able to get that mitigated down below the 30 days? Um, through a Douglas analysis
Yeah.
when you're being charged with willful misuse.
I personally haven't, when I, argue when that comes up, and, it's something that does come up at times, um, you know, you could argue, certainly the mitigating factors and whatnot. But one way to do it too is, kind of spin it as, you could have charged this in another way. And, really, it kind of comes down to the proposing and deciding official on how they want to look at this, because they could rescind a proposal and charge it differently. So there are, sort of creative avenues you could take to sort of try to get that knocked down. But it is correct that, there is
Yeah.
a 30-day minimum.
And I would concur with that absolutely. It's you're dealing with the agency. You have to explain to them they don't have to charge statute. They can charge what we call minor personal use, or even they could knock it down within the decision, and get it,
Yeah, they could
reduced.
label it as poor
A
judgment or something
a
like that
hundred
if they wanted to.
100 years ago, when I was a lawyer for ATF, we would sort of do that too. So we have another question, and the question
Sure.
has to do with your due process, and your right to review the evidence
Yeah.
against you. Yeah, what point in the process does that due process attach when you have the right to review the evidence?
Yeah, so it's really when the proposal comes in, that's when you're either told how you could review the evidence, or you're given a copy of the evidence file. And that's when you get that packet of information. Now, say that you get something like a proposed removal and it ends up unfortunately being sustained. Well, at that next stage, you would go to the Mayor Systems Protection Board, which, I could give a whole session on the Mayor Systems Protection Board. But you have full discovery in MSPB, and that's really where you could uncover, was there anything else looked at here? And ask for documents. What did the proposing official look at? I've actually, seen more documents come in than were provided to my clients at in discovery at MSPB before, and that's where you could raise, a due process violation. I
So this
hope that
last
answers the question.
Yeah, no, it's a perfect answer. So this last question, has to do with your Giglio analysis, and I'll maybe ask it a little bit different. Essentially, the question is, so a lack of candor charge can lead to a Giglio impairment. A twist on that question, I would ask you, do you see any difference between whether the lack of candor leads to Giglio versus a straight out falsification charge? Is there any difference in the two?
To be frank with you, Tony, no.
Okay.
Well, I mean, there's a difference in between the elements to prove the charges. Falsification requires an intent to deceive, which lack of candor does not. But in my experience, agencies almost go the lack of candor route because it's easier for them to prove in litigation. And both of them could lead to what agencies call potential giglio impairment. Now, is it actual giglio impairment? Ultimately, that's up to the United States Attorney's Office, but agencies will consider it very often to be potentially giglio impairing.
Okay. And some of these other questions, I think we can deal with at the end. Somebody's asking, are there policies and reports, that the agency says are not available for review? Can they omit exculpatory evidence? I mean, the bottom line, just to keep us moving, I think, Michael, what you're trying to communicate is everything relied upon to support the discipline needs to be provided to you, is the bottom line.
Yeah, that's the bottom line. Now, that does not mean that you cannot introduce, new evidence when you reply to a proposal. Again, I could give a whole session on replying to a proposed disciplinary action, but you are able to collect witness statements or, whatever it may be that you want to introduce. Maybe there's exculpatory information that the proposing official just, blatantly ignored. And that is just the frank of the matter at times. Well, you can introduce that to the deciding official. Now, whether the proposing official actually looked at it in the front end, we don't know that, but you could put that in front of the deciding official if you have it in your possession.
All right. Thank you.
Yeah. Um, so, we're going to this next chapter here, this next bucket where you may see allegations of wrongdoing in your law enforcement career. And we're really focusing here on Bivens lawsuits and RIFRA lawsuits. And you heard me earlier, a lot of you have probably heard of Bivens. It's been, since the 70s, kind of the main way people would file lawsuits against law enforcement officers in their individual capacity. But what I want to really highlight and emphasize in this presentation that is that RIFRA is on the rise, and I'm just going to talk a little bit about that law as well. So this is a little 101 on sovereign immunity. In short, the federal government is the sovereign, and because the government's the sovereign, it's immune from lawsuits unless it allows them to proceed. And so you, as a federal employee, as a federal law enforcement officer, that immunity, it extends to you. And how does the government waive sovereign immunity? Well, there's really two ways. It's the Constitution itself and then Congress. And that's really the main form right there is Congress. And so, an example of Congress waiving immunity, many of you have probably heard of Section 1983 claims. For example, George Floyd, there was a Section 1983 claim in that case. But Congress waived immunities for state officials who violate people's constitutionally guaranteed civil rights. And what I want to highlight here with that is that, and why I'm bringing it up as an example, is one, a lot of law enforcement officers know of this, but two, it came in the Civil Rights Act of 1871. That's over 150 years ago. Now, where is it for federal law enforcement officers? None. After 150 years, Congress didn't extend that to federal law enforcement officers. So 100 years after 1983 was enacted, the Supreme Court jumped in with Bivens v. Six Unknown Named Agents. It's a 1971 case. And there, FBI agents, they violated someone's Fourth Amendment right against unreasonable search and seizure. And what the Supreme Court held was that the Fourth Amendment implicitly entitled plaintiffs to recover money damages against those agents. And really, since 1971, the Supreme Court really hasn't acted on it too much. It came up two more times. They extended Bivens twice, once in 1979 and then once in 1980. Since then, there have been no new Bivens causes of actions allowed by the Supreme Court. And really, what the Supreme Court has been doing is walking it back. I highlight two more recent Supreme Court decisions here, Ziegler v. Abbasi and Egbert v. Boulay. And what they're saying in those cases is, go look to Congress. Why are you looking at us for a cause of action? Go look to Congress. And, they basically say if there's any reason Congress is better equipped to create a damages remedy, look at them. And it could be all sorts of factors. And the case laws really, lay those out beautifully for you if you ever find yourself the subject of a Bivens complaint. But that's what, in short, what the Supreme Court has said is go look to Congress. Now, There is a congressional action that is relevant to you. As I mentioned, RFRA, the Religious Freedom Restoration Act of 1993. And what RFRA basically is, it protects the free exercise of religion. And two parts of it I just want to emphasize for you because I'm going to explain why, but they come up again, is that it says that the government shall not substantially burden a person's exercise of religion. But then it also says when, that exercise of religion is burdened, the individual may obtain appropriate relief against a government. So this was 1993. I'm going to fast forward to 2020. Between that time, the Department of Justice zealously fought against these causes of actions under RFRA being extended to federal employees in their individual capacity. But in 2020, we see Tanzin v. Tanzir. It's a Supreme Court case. And there, it was basically the plaintiffs were placed on a no-fly list, and they were saying it was retaliation for refusing to become informants. And what that case really opened up were two questions for the Supreme Court to address. The first is, can a government employee be sued in their individual capacities under RFRA? And the second is, if so, what's the appropriate relief? Well, I'm sure that everyone attending this presentation today is aware of sort of the makeup of the Supreme Court today. And, we have our conservative justices and we have our liberal justices. Well, very often do they see eye to eye on things. I think we can agree on that. But with Tanzin v. Tanzir, we have a 9-0 decision, a unanimous decision by the Supreme Court. As a lawyer and a nerd, I think that's quite remarkable. And, what the Supreme Court, what all the justices said was yes, government officials can be sued. They say that with RFRA, Congress waived that immunity. And it allows you as a law enforcement officer to be sued in your individual capacity. Then they turn to the question of appropriate relief. They say, it's open-ended, it's context dependent. But, the part that's really relevant to you is that they say that monetary relief is often the only form of relief for a RFRA violation. And that financial liability is on the individual. It's on you, not on the government. So, this is where we expect litigation to go over the next 5, 10, 15, 20 years, is the Department of Justice trying to move the form of relief away from monetary forms to more equitable forms of relief, like implementing new rules, directives, policies to hold its employees accountable, taking corrective actions of some sort. That's the sort of relief we expect the Department of Justice to be moving towards and trying to get the Supreme Court to back away from, an open-ended form of monetary relief here. And so, really what I wanted to emphasize with this slide, we see, the rise of the moon here. And it's really showing that RFRA's on the rise. Bivens, it's dying. You don't see people being liable under Bivens anymore. But where litigation is and where it's going is on RFRA. And, you could sort of imagine the sort of types of litigation where you see RFRA percolating in the district and circuit courts. Well, we have COVID era vaccine requirements. There's prisons, so bans on growing beards, that could violate some kind of religious adherence. Or, say that you work for the U.S. Postal Service and you have a Saturday or Sunday tour of duty, that may violate the Sabbath. So that is really where the litigation is going and what to keep an eye on going forward. Now we're moving on to the last sort of area of our presentation here, the last bucket where you may have allegations of wrongdoing for, doing your job duties. And it's the area that we're going to spend the least amount of time on, but it's really criminal investigations and prosecutions for allegations of wrongdoing. And really, there's a handful of um, criminal offenses that law enforcement officers are prosecuted on and investigated on by the Department of Justice. And so, I just lay them out here. And they're all kind of obvious. One is the use of lethal force. And that's for obvious reasons. If you improperly, use lethal force, you may be investigated and prosecuted for it. If you're involved in quelling a protest, and the Department of Justice thinks that your actions were wrong, you may be prosecuted for the deprivation of civil rights. Falsification always comes back to telling the truth in investigations. You could get charged not just administratively on the administrative sides of things, with like a proposed disciplinary action. Like say lack of candor, you could also get charged or prosecuted criminally for lying. Then there's also perjury. So, say that you're involved in completing search warrants, lying in a sworn document, that could get you prosecuted. And then the last one's obstruction of justice. So if you, are investigating a suspect and you go and destroy evidence, that could get you prosecuted. But that really wraps up, the three buckets that I wanted to, flag for you on where you may see allegations of wrongdoing in your law enforcement career. Again, we talked about, sort of the administrative side of things, so investigations, disciplinary actions against you, and your appeal processes and rights. Then we have the civil suits, so actions taken against you in your individual capacity, lawsuits. And we talked about how Biffins, that's kind of dying, and RIFRA, it's on the rise. And then criminal charges and investigations. That's the last bucket we have here. And so, Tony, I'm going to turn it over to you. I have a slide on
Sure.
professional liability insurance.
So we'll run through this real quick with the essence of time. Appreciate all that. The insurance essentially provides protection for those three buckets that Michael just discussed. Administrative matters, you're covered what I call cradle to grave. It's an old law enforcement term from the start of the investigation up into the conclusion. The unfortunate event, there's a disciplinary action taken against you. It defends you both at the agency level and any appeal to the MSPB up to 200K, which is plenty to get you through that. Civil lawsuits, the civil protection is twofold. One is Department of Justice representation of you in a personal capacity lawsuit. It's not automatic. It's a two-part test. Your scope of employment and is it in the interest of the United States to represent you? So if they say it's not in the interest of the United States to represent you, you could be on your own to defend. So the insurance would provide legal defense for that. People ask me, when does that happen? Bottom line is if you're being investigated for some sort of misconduct for the same reason you're being sued, you can see how the Department of Justice is not going to want to be on both sides of that. It also provides indemnity protection. So regardless of who is representing you, whether it's DOJ, your own lawyer, our lawyers, if we lose, it's still a personal capacity case against you. So the government refuses to indemnify you. It is your pocketbook. So we provide indemnity protection up to $3 million, depending upon what limit you get. And then finally, as Michael mentioned, there is potential criminal exposures. What I like to say is, look, there's very little you can do wrong in the federal government and not also have it be a violation of Title 18, which all of you know is the criminal code. There's plenty of crimes in there where intent is not a prerequisite to prove it. So we cover any act or omission that results in a criminal violation. What I really want to emphasize here is I founded Feds on this platform of education. Full disclosure, I used to be a partner at Michael's law firm many moons ago, but I founded Feds on this platform of education because often incompetent legal services. The quality that you're going to get, like at a law firm like Shell Branson or Roth, is just cost prohibitive. The insurance only costs $290 annually, and because you are all law enforcement officers, the agency pays up to one half of the cost. That's statutory. So this is an employee benefit, that you really ought to be taking advantage of. It's going to cost you more to sit down with Michael for 1 hour than your annual premium is going to cost you each year. I often tell people, look, you could, buy it your whole career. You're going to spend $5, $6, $7,000 and just have peace of mind that it's there and never use it. Okay. That's not going to change your standard of living when you retire. But if you got to pay Michael 50,000, 100,000, 200,000 and up, and we've seen it, you've got to get second or third mortgages, on your home, takes the loan out against your TSP. It is going to impact your standard of living when you retire. So there's more information you can get on our website at fedsprotection.com. The final emphasis thing I want to emphasize here, because I can't tell you how many calls I get, is the coverage needs to be in place before the claim arises, right? Can't get in a car accident on Monday by your car insurance on Wednesday, or what I like to jokingly say, you can't buy your homeowner's insurance after the National Weather Service names the hurricane. So with that, fedsprotection.com. With that, I'm going to kind of turn it back over to Michael and open it up and that was a wonderful presentation, Michael. Really appreciate you sharing that information with us. I want to see if we have any lingering questions. So we'll sit tight here for a little bit.
Sure. Thanks, Tony. It was my pleasure.
So one question here that I'm sure you get all the time, do agents have any remedies when false accusations are made against them? And, we get it a lot with managers too, and employees, file false allegations against them. What are their options, Michael?
Yeah, I mean, if there's false allegations against you, I mean, let's just put it this way. Employees have a right to file complaints. And you, as a federal employee, if it's administrative, you're required to cooperate with investigations into those complaints. And, I can't tell you that, every one of the clients I've represented have had to fight against frivolous allegations against them. But, what it really is, it comes with the nature of your job. Especially if you're like a manager in the federal government who makes personal decisions affecting others. Now, what rights do you have? You have the same rights really as everyone else. But, I always caution my clients to proceed cautiously, when filing complaints and all that, because, it could impact your defense and responding to allegations against you. So, that's the long and short of it, I guess.
I mean, it's a question I get every single day, what I do here. And it's just, you're in a tough situation. I mean, honestly, if somebody's filing a false complaint with reckless disregard for the truth, we're all in law enforcement here. You're all in law enforcement here. That's something the agency should do something about. But frankly, I have found that they don't, because they're done under this protective environment of the complaint process. And it's frustrating as somebody who defends you all, because if we were if we were alleged to have made false statements during the investigation, they sure in fact might have some issues for us. Michael, one final question here. They want to know, is there any, what the statute of limitations is for any sort of Bivens or civil action? Is it 2-3 years? And then the second part of that question is, is there any point, like, does the agency have a statute of limitations to take disciplinary action?
Okay, yeah, I can answer that. So, the statute of limitations for an action against you, kind of largely depends on the court in which someone's filing in. And that statute of limitations really varies across the country. So, while you may have a statute of limitations in like the Eastern District of Virginia that, says one thing, you may have a different one in the Southern District of New York that says another thing. And so that's really how statute of limitations are governed. Um, and then the second part of the question, a statute of limitations for the government to sort of act on allegations against you. No, there is none.
Right.
Now, I've seen clients get allegations that are like 7 years old, and surely, you can make argument. There's argument you can make, like staleness is something that comes up in Merit Systems Protection Board case law. And it's an argument you can make, like, this is stale. This is old. This is 7 years old. Why are you acting on me now? And often when there's something like that, there's maybe some kind of reason, whether it was like a very long, drawn out investigation. Maybe there was a change of management, and your former supervisor didn't want to act on it, but it's on the chair of the new supervisor and he's told to do so. So maybe that's how it happens. There's sometimes a reason for it, but sometimes there isn't at all. But there is argument they can make called staleness.
Yeah, I mean, the longer it takes them, the harder it is for them to prove that the penalty is reasonable, in my opinion.
Yeah.
So the last question is really for me. Does the Board of Governors of the Federal Reserve System, do they have to pay one half for their LEOs? I believe the answer to that is yes, but go ahead and email me. My email is Tony, Tony, at fedsprotection.com, and I'll get you a concrete answer. Also, if anybody has any questions about their reimbursement policies and how you do that, we have most of the agency's policies available on our website. But you can also just get on your intranet, your agency's intranet, and literally just type PLI reimbursement and your agency's policy should pop up there for you. So I think that's it, Michael. Thanks again. I appreciate, you spending some time with us and sharing this important information. And I thank all of you for attending.
Yeah, it was my absolute pleasure.